My time is almost up. I want to ask you another question. In the Senate hearing, in response to Senator Wyden's question of whether the FBI is currently purchasing Americans' location data, you indicated that it was limited to data derived from Internet advertising. It's since been reported that the FBI has admitted it bought U.S. location data. Is the FBI purchasing location data from commercial sources without a warrant?
This is an area that requires a little more precision and context for me to be able to answer that fully, so let me have my staff follow back up with you so that I make sure that I don't leave something important out.
I'll disclose with the FBI had 3.4 million backdoor searches of the FISA database without a warrant in 2021. Can you say whether the FBI is continuing to search the FISA database without a warrant for Americans?
Well, if you're asking about our use of 702 queries, those are, there is no warrant requirement under the Fourth Amendment for those queries. That's fairly well settled. The 3.4 million figure that you're talking about, I guess I would say a couple things. One, that's not 3.4 million people. That's 3.4 million search terms or query terms. Second, that's not those are not queries in violation of rules. Those are just queries under the
My time has expired, but the committee will look into the warrant requirement later.
Sure will. You sure will. The gentleman from Florida is recognized.
The American people need to understand what just happened. My Democrat colleague just asked the director of the FBI whether or not they are buying information about our fellow Americans, and the answer is, well, we'll just have to get back to you on that. It sounds really complicated, but I have other questions. I'm sitting here with my father. I will make certain that between the man sitting next to me and every person he knows and my ability to forever hold a grudge, that you will regret not following my direction. I am sitting here waiting for the call with my father. Sounds like a shakedown, doesn't it, Director?
I'm not going to get into commenting on that.
You seem deeply uncurious about it, don't you? Almost suspiciously uncurious. Are you protecting the Bidens?
Absolutely not. The FBI does not and has no interest in
you won't answer the question about whether or not that's a shakedown, and everybody knows why you won't answer it. Because to the millions of people who will see this, they know it is. And your inability to acknowledge that is deeply revealing about you. But let's go from the uncurious to the downright nosy. How many illegal FISA queries have occurred under your leadership of the FBI?
Well, there are reports that have come out with different numbers about compliance incidents.
More than 1 million illegal ones? Because that's what the Inspector General said. The Inspector General said that in the 3.4 million of these queries, more than 1 million were in error. Do you have any basis to disagree with that assessment by the Inspector General?
I'm not sure actually that's a correct characterization of the Inspector General's findings on that.
The internet will remind you of that in moments. But let's now go to what the court said. The court said it was over 200,000 that have occurred on your watch. Do you have any basis to disagree with that assessment?
Again, I don't have the numbers as I sit here right now. What I can
Seems like a number you should know. How many times the FBI is breaking the law under your watch, especially if it's like over 1 million, to not know that number? And I'm worried about your veracity on the subject as well. Play the video.
Letters for investigation of the Capitol. I don't believe FISA is remotely implicated in our investigation.
So there, Senator Lee's asking you whether or not FISA was in any way involved in your January 6th investigation, and you say no. Was that truthful?
I said that I did not believe it was.
Okay, so now let's pull up what the court said, which was something a little different than what you said. So here, nope, that's not the right one. Yeah, here we go, right there. It says, the government has reported additional significant violations of the querying standard, including several relating to the January 6, 2021 breach of the Capitol. So I guess the question, Director A, is did you not know when you were answering these questions that the FBI was engaging in these illegal searches, or did you perjure yourself to Senator Lee?
I certainly didn't perjure myself. At the time that I testified in front of the Senate Judiciary Committee, I didn't have that piece of information. I will add...
Well, that was a court order. You didn't have that piece of information because the court hadn't yet rendered a judgment. Did you not know when you gave the untruthful answer before Senator Lee that this was going on?
It was a truthful answer. I did not believe FISA had been involved in the January 6th
But it was. So you didn't... The answer is the FBI has broken so bad that people can go and engage in queries that when you come before the Congress to answer questions, you're like blissfully ignorant. You're blissfully ignorant as to the unlawful queries. You're blissfully ignorant as to the Biden shakedown regime. And it just seems like it gets into a kind of a creepy place as well. Go to our next image on what the court said. Like, just so the American people realize, the court has smacked you down, ruling FBI personnel apparently conducted queries for improper personal reasons. People were looking themselves up. They were looking their ex-lovers up. Who has been held accountable or fired as a consequence of the FBI using the FISA process as their like creepy personal snoop machine?
There have been instances in which individuals have had disciplinary action and who are no longer with it. I can't get into it here, but we can follow back up with
Don't you see that that's kind of the thing, Director Wray, that you preside over the FBI that has the lowest level of trust in the FBI's history? People trusted the FBI more when J. Edgar Hoover was running the place than when you are. And the reason is because you don't give straight answers. You give answers that later a court deems aren't true. And then at the end of the day, you won't criticize an obvious shakedown when it's directly in front of us. And it appears as though you're whitewashing the conduct of corrupt people.
Respectfully, Congressman, in your home state of Florida, the number of people applying to come work for us and devote their lives working for us is up over 100%.
We're deeply proud of them, and they deserve better than you.
Time of the gentleman has expired. The gentleman from Tennessee is recognized for 5 minutes.
I'm going to talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges Kohberger around the King Road residence. And this same claim is in Exhibit A signed by Detective Blaker.
Give me just a minute, Your Honor.
Sure.
Thank you, Detective Mallory. I don't have the other questions for now, but hold on, the prosecutor might.
Thank you, Ms. Taylor. Ms. Jennings, Mr. Thompson? Ms. Jennings. Okay, Ms. Jennings?
Mallory, I want to go back and talk a little bit about this CastViz program. Can you explain to me generally what is CastViz?
It's just a software that is useful in creating visualizations of the bulk detail records.
Okay. So how is it useful? What does it show?
It shows the location and the direction of the cell towers and their sector antennas.
Okay. Now, what version of CastViz do you have?
Currently, I think I have 33 on my laptop. It's prompted me to update to 38. But at the time, I believe I had 30 installed.
Well, this is inaccurate. The officer signing the affidavit did not claim to do the cast work.
So walk me through. You start up the software program.
Yes.
And then what do you do?
Drag the text file from the CDRs into the system. It ingests the files and then produces a display of that data.
Okay. And is that what you did on the 19th?
Yes.
The officer signing the affidavit did not claim to do the cast work.
And then what did you do with that visual that was displayed?
The visuals, I created screenshots, created the screen capture of the video. CastViz also allows a timeline playing view that you can record separately with Windows Code and some software. Save those.
Other than uploading the CDRs,
The officer signing the affidavit did not claim to do the cast work.
other than uploading the CDRs,
Did you mean AT&T?
Yes. They didn't claim to have gotten those records and put them in to their program to determine the approximate locations of the phone.
other than uploading the CDRs, did you change any of the settings on CastViz?
The only thing that I would have done was gone in and changed made sure that the time was correct because they were coming in at the TC. It was a coordinated time. I wanted to make sure that those were representative of the local time.
Okay, so you just changed it to Pacific.
Correct.
Any other changes?
No.
That was done by Special Agent Balance. And the affidavit makes that clear. And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does, the experience that's involved, SA Balance's own experience. And then the law enforcement officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458 phone.
So you were talking about how it does not automatically save.
It does not.
Okay. and you chose not to save.
No, and in the exhibit that was provided, the actual text says that if you need to save the session file.
Okay. And can you tell me, why didn't you save these settings?
I was creating the visualization exhibits. That's what I was doing with that.
Any reason to save the settings?
No.
Could this be recreated or redone in the same fashion?
Yes, I can, again, open the software, drag the CDRs back in a very short time it is generated.
And it would give you the same information?
Yes.
Is that why you didn't save it?
Yes.
That's not claiming to have done the CSLI work, but instead is just a reflection. The work was done by balance, investigators reviewed that, and then made some determinations of the approximate locations for that 8458 phone.
I want to switch over to the other session files that you found. Were those session files created by you?
No.
Okay. And did you ever use those?
No.
And have you now turned those over, provided those?
Yes.
The work was done by balance, investigators reviewed that, and then made some determinations of the approximate locations for that 8458 phone.
Let's talk about that time frame then and what you did. Did you actually use a CastViz program at that time to create something?
Yes.
I'm gonna talk a little bit about this idea that there's some issue with who did the work.
With the CastViz program, what's the first thing that you did?
Once the program is open, you can drag and drop the CDR records into the program.
CDR means call detail records.
Right.
Did you do just 48-hour records or did you do full records in April of 2023?
I only did 48-hour records.
They didn't claim to have gotten those records and put them in to their program to determine the approximate locations of the phone.
How many times did you use the CastViz program in relation to Brian Kohberger's call detail records?
I don't know.
More than once?
I recall doing it for the grand jury because I wasn't the main lead in the call detail records investigation.
I don't understand what that means.
I wasn't the main person looking at those call detail records.
You weren't the main person with the call detail records, but you put them in the CastViz program anyway?
For the grand jury, I was requested.
Okay. What did you rely on in producing those? Producing whatever you produced for the grand jury?
What did I produce? As far as the AT&T records?
I want to know what you relied on to do that, to produce something for the grand jury.
I don't understand the question.
Okay. You weren't the main guy with the call detail records or with the CastViz programming. Did I understand that much right?
There was another investigator that was doing it.
Okay. But you end up involved in it somehow in April of 2023, is that right?
That's why I was asked to examine the data to provide that for the grand jury.
Okay. Was that all of your instruction?
What do you mean by that?
Well, you're asked by somebody else who's actually doing this part of the investigation in the case to produce something for the grand jury to use. And I'm curious about what you relied on, to get to that point. I want to know all the records you relied on, all of the emails, all of the conversations you relied on to produce this thing that you're not the expert for.
So I wrote the affidavit for the AT&T records, received the AT&T records. Those records were also given to another investigator who was the main investigator doing the CDR records. Prosecution then asked me to provide or create some type of visualization of the call detail records and examine the call detail records for the 4 hours in question.
That was done by Special Agent Balance.
Just to be really sure, when you talked about writing the 2 warrants for AT&T, we're talking about 2 warrants that relate to Brian Kohberger. There were a lot of other warrants. Is that right?
Correct.
Okay.
Yes.
I just want to be really clear on that.
Chair now recognizes himself for an opening statement. 8 days ago on July 4th in the Western District of Louisiana, the court found that the federal government suppressed Americans' First Amendment free speech rights. In his conclusion on page 154, the court said this, the judge said this: plaintiffs are likely to succeed on the merits in establishing that the government has used its power to silence the opposition. Opposition to COVID-19 vaccines, opposition to COVID-19 masking and lockdowns, opposition to the lab leak theory of COVID-19, opposition to the validity of the 2020 election, opposition to President Biden's policies, statements that the Hunter Biden laptop was true, and opposition to policies of the government officials in power. All were suppressed. It is quite telling that each example or category of suppressed speech was conservative in nature. The court further writes, the United States government seems to have assumed a role similar to an Orwellian ministry of truth.
It's hard to see, isn't it? What I want to know is what you relied on to get that first one that talks about WSU and the cameras at WSU. So where'd you get that?
Yes, ma'am. So Special Agent Rob Hilley with the FBI was also co-located with us. He was tasked with analyzing that video from WSU and the surrounding area. So it was a conversation between he and I, pointing out areas of locations where the car was likely seen on surveillance footage. And that's what I relied upon to create that map.
So you created that map how?
Through PowerPoint, I believe, and memory serves.
You saved your work on that?
Yes, ma'am.
Let's go to the next map. That one would appear to be a trail or a path from south of Moscow back towards Lewiston or back towards Palmer. Is that right?
Yes, ma'am.
Where did you get that now?
Same thing. It was just created using open source satellite imagery and I think it was PowerPoint.
Did you create that?
Yes, ma'am.
Where did you get the information to draw that trail?
So that was used from the cell phone records referred to me by Special Agent Balance on his interpretation of possible places where someone could have driven between the location that starts there and then back to Coleman.
So you did this on some open source mapping, not anything from Nick Balance creating a visual for you?
No, ma'am. I did view a draft report from Special Agent Balance to help me conceptualize this, but it did not look like this map.
Where's that draft report?
It is, best of my knowledge, it's already been provided to the prosecutor's office through the FBI channels.
Is this the lengthy past draft report or is it a different draft report?
Well, it would have to be the draft cash report. That's the only cash report I'm aware of from Special Agent Balance.
Specific to the FBI, the court said this: the FBI's failure to alert social media companies that the Biden laptop story was real and not Russian disinformation is particularly troubling. The FBI had the laptop in their possession since December 2019 and had warned social media companies repeatedly to look out for, quote, hack and dump operation by the Russians prior to the 2020 election. Even after Facebook specifically asked whether the laptop story was Russian disinformation, the FBI refused to comment, resulting in social media companies' suppression of this story. And as a result, millions of our fellow citizens did not hear the story prior to the November 3rd, 2020 election.
Today is the first one. And was there anything else from AT&T that you saw or relied on to get the second one off the ground?
No, ma'am.
And in the first AT&T search warrant, are you aware that part of the request was for timing advance reports?
Yes, ma'am.
And in fact, that also appears in your second search warrant request, right?
Yes, ma'am.
All right. And not only do you ask for the timing advance reports from AT&T, you asked for them from several other companies, correct? Verizon's version of it, T-Mobile's version of this kind of timing advance report. Is that right?
Yes, ma'am.
All right. When was the first time you saw AT&T's timing advance report?
I do not recall when I first saw it.
Where is it?
To the best of my knowledge, all that information from those returns has been provided to the prosecutor's office.
If I tell you I don't have a timing advance report or any from the other phone companies, where do I look for them?
I would direct you back to the prosecutor's office. Everything that Moscow PD received me in that realm, we have turned over to my knowledge.
But you know you've seen this report, is that right?
I do not recall if I've seen the timing advance reports. I'd have to see what it looked like to know if I've seen it.
Do you know what it is?
Not particularly. I'm no expert.
Okay. You wrote the search warrant though, right?
Yes, ma'am.
Well, how did you get the language for that if you don't know what this is?
So There's no secret that I rely heavily on people who are very highly educated in these topic areas to write the search warrant. So that language was likely conveyed to me through people who know much more than myself about cell phone data.
Who are those people?
Like I said, FBI agent Balance and Detective Mallory were probably my two main points of contact for helping me with that language.
During the course of your investigation and work on the case that became the case that we're here for now, did you communicate with Agent Balance by email?
Yes, ma'am.
And did you communicate with other FBI agents by email?
Yes, ma'am.
And did that relate to the investigation of the scene and later the investigation of Brian Kohberger?
Certainly, yes, ma'am.
Were those communications that assisted you in preparing affidavits and search warrants to carry out your duties in the case?
I do not recall.
But you recall the emails themselves?
I recall sending emails to FBI agents, yes, but specifics though.
And receiving them?
Yes, ma'am.
Where are those emails now?
All emails that Moscow PD is aware of have been turned over to the prosecutor's office.
All right, I can have just a minute.
Sure, thank you.
Thank you. I don't have any other questions for now, but I think you have a couple of exhibits on that front end. If you don't need them for us, maybe I'll take them back.
Additionally, the FBI was included in industry meetings, bilateral meetings, received and forwarded alleged misinformation to social media companies, and actually misled companies in regard to the laptop story. When the court says the FBI misled, that's a nice way of saying they lied. They lied, and as a result, important information was kept from we the people days before the most important election we have, election of President of the United States, election of the Commander-in-Chief. In a survey last fall, 4 out of 5 Americans said they believe there's a two-tiered system of justice in America today. They said that because there is. They said that because of what they've witnessed. Think about what Americans have seen. National School Board Association, left-wing political group, writes the White House and asks them to treat parents at school board meetings as terrorists. And the Garland Justice Department does just that. They put together a memo, set up a dedicated line of threat communication, a snitch line on parents. As a result, parents get investigated by our FBI, get a threat tag associated with their name, 25 of them, because whistleblowers came and told us we're investigated by the Federal Bureau of Investigation.
Other investigators tell you you're applying for warrants?
Absolutely.
And is that what you did?
Yes, ma'am.
And is what you relied upon detailed in your probable cause affidavit?
Yes.
Now, talking about the timing advance records, are you aware that AT&T didn't provide timing advance records in December of 2022?
I do not remember.
Are you aware that they did not start providing those records until May of 2023?
Objection, Layton.
Cross-examination.
It is overruled. Go ahead.
I'll re-ask. Are you aware that AT&T did not start providing those records until May of 2023?
Yes.
I don't have anything further.
Thank you. Ms. Taylor?
Thanks. Let's start there. May of 2023. Do you have timing advance records now for May of 2023?
I would have to direct you to Detective Mallory to answer that question. Don't know.
Okay. Did you write a new warrant for them in May of 2023?
I do not recall.
If you included them in 2 separate warrants in December of 2022, but they didn't provide them, why would you do that?
With the language that was suggested to me to write the affidavit. So
Language suggested by an FBI agent who's an expert in the field?
yes, ma'am.
Yes. And do you know if he saw the timing advance reports?
I do not know.
All right.
Americans have seen the FBI's Richmond field office put together a memorandum saying pro-life Catholics are extremists. They've seen 20 FBI agents, SWAT team members, show up at the home of Mark Houck and arrest him in front of his wife and 7 children, even though he had indicated he'd be happy to turn himself in. And what was he arrested for? Him and his 12-year-old son were praying outside an abortion facility. Some guy starts screaming in his son's face, and he did what frankly any dad would do, defended his child.
Now, those first and second AT&T warrants were how many hours from receiving the return on the first one until the second one was given to Judge Marshall at 4:45?
I do not remember.
Not very many hours, though. Would that be fair?
Likely not.
What's interesting is the National School Board Association apologized for the letter, but the Attorney General refuses to rescind his directive. The FBI did rescind, thank goodness, the Richmond Catholic Memorandum, but they refuse to tell Congress who wrote it and who approved it. And Mr. Houck, when he got his day in court, he was acquitted by a jury of his peers.
do you have a sense as to whether these records matter to us and what we're doing to defend Mr. Kohberger?
Given the timing of these records, from what I can tell in the emails that were produced by Detective Mowry, these records were generated on the 23rd of December. It's when everything started with probable cause statements. If I had to pick a time when the wheels fell off the wagon, that's the date. There are statements and there's assumptions made in the records that will never be supported by the data. There's a lot of claims that are said in these emails, and even the name files of the records are problematic. It does not represent what it's claimed to represent.
Sounds like those might be pretty important to us defending Mr. Kohberger.
I could give examples, but I know it's a very technical thing, so I'm not. It could be extremely impactful to either side. I'm not saying just in defending Mr. Kohberger. It could be extremely impactful in prosecuting Mr. Kohberger. The problem's the problem, not what the data helps or hurts.
American speech is censored. Parents are called terrorists. Catholics are called radicals. And I haven't even talked about the spying that took place of a presidential campaign or the raiding of a former president's home. But maybe what's more frightening is what happens if you come forward and tell Congress. If you're a whistleblower, come tell the legislature, come tell the Congress what's going on. Look out. You will be retaliated against. Ask Garrett O'Boyle, who told Congress about these issues. Took his clearance, they took his pay, they took his kids' clothes. Ask Gary Shapley, 14-year veteran at the IRS, handled some of the biggest international tax fraud cases at the agency. He comes forward, and the Justice Department kicks him off the case. But here's what's truly unbelievable. Here's what's amazing. With all that history, with all that, the Justice Department and the FBI want the taxpayers they censored, the parents they labeled, the pro-life Catholics they called radical, they want them to pay for a new FBI headquarters. And they want FISA reauthorization of the 702 program in its current form. It's in the director's opening statement. I mean, you can't make this stuff up. There are 204,000 reasons why Republicans will oppose FISA reauthorization in its current form. 204,000 times the FBI improperly searched the 702 database. And unlike the FBI censorship in the court's opinion that was focused on conservatives, the FBI's illegal scrutiny wasn't just limited to conservatives. BLM supporters were illegally scrutinized by the FBI as well. And I hope our Democrat friends will join us in opposing reauthorization of Section 702 the way it's currently done. And I think they will. And I hope they will work with us in the appropriations process to stop the weaponization of the government against the American people and end this double standard that exists now in our justice system. With that, I yield to the gentleman from New York for an opening statement.
Desperate to find out the timeline in this case and when the state knew what and when. There's no question that motions to suppress are coming. Motions to suppress are coming on warrants. And whether or not those motions to suppress are based on Frank's material because misrepresentations are made depends on the timeline. So if there's a representation made in a warrant that things happened in a certain way, if we are able to look at the timeline and say, we know that the state knew this when, that gives us an answer on whether or not the suppression issue includes a truthful statement in the affidavit. And if I'm not making sense, I want you to tell me to clarify that. But we need to know the timeline of all of the evidence in this case and when the state knew what it knew, or why certain things were being looked at before Mr. Kohberger's arrest or well into late in the year in 2023 related to the victims, and try to piece together, is that something that the state is still seeking because they're pursuing the alternate suspects that exist in this case? There's so many things that we're trying to understand. So what we're asking you to do is enter an order compelling them to produce the subpoenas. You see that they had at least two in their possession that they possess, and it will clarify it for us.
Nicholas Balance as well.
Yes, ma'am.
What was the distance that you had in proximity to him?
He sat in the same lab that I did.
And so was that a cubicle setting? Can you describe the setting?
It's a secured forensic lab. It has a door.
And then inside, is it open? Were you in separate offices?
It's a single room.
Single room. And so you were literally in the same room with Agent Balance?
Yes, ma'am.
And was that for the entire time that he was co-located there?
Yes, ma'am.
Were you aware of his ability to have access to AT&T records without a warrant?
No, ma'am.
Your Honor, item 2B in our fourth motion to compel is item 224. That's the cast biz log. And this one is rough. The court heard last week Detective Mallory say, I don't have any of those, except I found these other items that we'll give you now, which were not Mallory's cast biz logs. The hard part for us about this one, Judge, and I have to make a record, I think you can order them to double check, and I'm going to ask you to order them to double check. But the hard part of this for me is that on January 9th, we asked for these cast biz logs. And the response from the state was cast biz does not produce logs. And that's just not true. It does. It's capable. It produces logs. You've heard that in the testimony. Then we filed our motion to compel and explained we have an expert, it produces logs. We're going to bring them. And the response was the working files were not saved. We received that response on April 23rd, 2024. And then on May 10th, we got a little bit more explanation about default settings were used and optional session files were not uploaded. This is really, really difficult because of the varying answers that we've received. The court's heard testimony from Mr. Ray about how important these logs are to know what was done. This is really challenging. We can't recreate what Detective Mallory, who testified before the grand jury, did, unless the court orders that we get the tower list he used and we have the cast biz program. And quite frankly, that's what we want. We need to see how this work was done. This is important work. I'll tell you the other thing that's really troubling and frustrating, aside from the other files that we received in preparation for motion to compel, is these screenshots that we got for the first time last week when we're on a motion to compel and have a witness before the court. We didn't have those screenshots that Detective Mallory had created before. The only thing we had was Exhibit 48 that was given to the grand jury, which is a video that was handed over then. So this is really problematic to be told these varying things and then have something else produced on the day of testimony. Your Honor, we are going to request that the court order that we have the tower list used by Detective Mallory and access to the cast biz program so our expert, Mr. Cy Ray, can go through and see what Detective Mallory did. That it's imperative that we be allowed to do that. That's the only way to recreate what Detective Mallory did.
It seems to me he did acknowledge that he just went back and provided this a day or 2 days before he testified that he found this additional information. So I'm thinking that the state got that information and had provided that to you. Now, we also heard a lot of the quotes missing pieces today, which I'm guessing that FBI, Mr. Valance and Detective Mallory are going to go back through that and see if there's something else. At this point, I'm assuming that some things may have fallen through the cracks. It is very complicated. There was a lot going on. We have some time before a trial. I just hope that everybody goes through their computers or their files or whatever they're going through so that it's complete. So what I've been watching over the last 2 months is that there have been supplemental responses to the defense. So things were coming in. They were waiting for information to come in so that they could provide that to you. So that's why I don't want to go backwards either. I just want to make sure that we are addressing what you don't have and what actually you're entitled to. So that's the tower list. I mean, I don't know anything about tower list, so I'm learning about that. I don't know that Detective Mallory addressed that, really, unless I missed that.
Your Honor, I believe he testified last week that he used the tower list that was contained in the AT&T record that he received. You heard today that doesn't exist. And you heard today that the tower list was something different that he used. And that tower list had once that was entered, there was a selection on the program to do tower density as well.
Like I said, it's confusing.
It is. It definitely is.
We'll keep going.
Okay, thank you.
You want the tower list?
Yes, I think I'm getting there, but I definitely want that. I want the one that Mallory used to do his cast biz work back in May of last year. That's the one I really want right now, at least at this juncture in the documents right now. I do want to clear up though, when we talk about what Detective Mallory found last week when he was preparing to testify, those are emails between him and Nick Valance. Those are JSON files from Nick Valance to Detective Mallory. None of those things that he found, other than screenshots, like the exhibit that you have of his map with the different sized towers depicted, other than those screenshots, the other things he had came from Nick Valance. Those were not his logs that he found. Those were not his towers that he found. Just to be sure that those are still missing to the extent they exist. And we can't recreate what he did without the list and program.
Even if the person that made the statement on the team knows that that statement going into the affidavit that group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there. But that's not what happened.
Moving on.
Thank you.
Moving on then, Your Honor, is item 226. That's called the Hemisphere Program, also known as a Timing Advance Report. Your Honor, this is one of the troubling areas again. The first response was that the records do not exist. There were letters exchanged between the state and us asking for more information. In one of the letters from the prosecutor, we were told that this program was not used in Brian Kohberger's case. And then we filed a motion to compel, and we were told that the state was not in possession of the timing records. And then the next supplemental response in May of this year, just a couple of weeks ago, was to tell us that there's some new certified records from AT&T that we're going to get. I don't know what those are. I can tell you that these timing advance reports were asked for from AT&T, from Verizon, from T-Mobile, and another cell phone company. In both of the early AT&T warrants, we called them the 48-hour, and then the extended warrants back on December 23rd, 2022. We don't have those. So I just want to make a record that I need to know what happens. Moving on then to 228, item 228. That was trying to understand what was relied upon for the second AT&T warrant. And we heard quite a bit today from Detective Payne about what he relied on for that second warrant, and that had to do with what was produced and analyzed in the first warrant. However, we asked for some emails and some communications. We know about some text messaging that we've received, but we don't have written correspondence, email correspondence, exchanging information, just the text messaging. So we want all of the email communication between Payne and Balance, well, between anybody from Moscow PD and anybody from the FBI group. Your Honor, item 229 is the MAID data. I would say we received a disclosure, and I think we got that on either 510 or 517. And I'm going to need some time to have an expert help me out with that. I don't know if that's complete. I also know that in the fifth motion to compel, there is information we've asked for from Babel. That was a program that was used to help decipher some of the MAID data. And we're going to talk about that in a minute, but that one's yet to come. So I'm going to ask the court for an order compelling the state to give me all the MAID data. They may have already complied. So their intent to comply, I can tell you that.
What does that stand for again?
Mobile advertiser, let's see, I've got it in here.
Okay, I'm glad.
Identification number, mobile advertiser identification number.
Okay, thank you.
You're welcome.
Don't get caught up in thinking 7 minutes don't matter here.
All right, Judge, we are now talking about item 242, the CAST report. The history of this is we came to the court asking for the CAST report, knowing it was relied upon last year, and the court ordered that we receive it. We received one that was stamped draft all over it. You've heard testimony about that today from Mr. Ray, and it's not a final report, and we knew that when we got it. We asked for that. We asked for the analysis behind that, and we haven't received that. We were told on February 23rd of this year that the state will provide this by March 31st. Well, March 31st came and went, and we did not get it. So on April 23rd, the state said we still don't have it. And then on May the 10th, the state responded to this request and said that because we provided additional information, Mr. Kohberger's alibi, they need more time to do work on this CAST report, and they'll get it to us later.
I'll concede I think there's an issue there.
Your Honor, I think you ought to order that we get the CAST report, and I think you ought to order that we get everything that went into developing this, and we get the analysis that they made from that. This is particularly troubling. Their response, you told us something, so now we have to go reconfigure the CAST report. Let me tell you why that's troubling. Item 243 is our request. Give us a list of everything Nick Balance relied on when drafting his CAST report. And we were told Nick Balance relied on the call detail records from AT&T. Nick Balance relied upon tower records, and he relied upon the drive test data. Nowhere in there does it say, if you tell us anything about the case, we need that to rely on it too.
I'll concede I think there's an issue there. But that's not what happened.
These are records that exist. These are tower lists that exist. They go into a program. You do drive testing to understand how the device interacts with towers, and you create a report. So we're asking the court to order that we get the CAS draft report, we get the full list of everything he relied upon, and we get the analysis of what does this mean.
So another clarifying question maybe. So I listened to the testimony today, and that it sounded like a CAS report was provided, but maybe it wasn't complete. It's what Mr. Ray suggested. But I think that maybe I'm guessing, we're assuming that the state provided what they had, but maybe they're still working on it. I don't know. But didn't you get initially what they had as they characterized as the CAS report? So what do you say? I mean, we have problems with language, I think, especially when we're in this area of technology. And so we might be just going back and forth like this without really understanding what we're asking for or what we're providing.
Let me see if I can clear that up. The testimony today, when we had Detective Payne on the stand, when we talked about what did you rely on to get the second AT&T warrant, he said that there was something that Nick Valance produced and that the prosecutor had it, and he thought it was a CAS draft. And then you heard from Mr. Ray, who said, I've seen the CAS draft report, and maybe it's something different that Detective Payne looked at. It wasn't this big long CAS draft. The CAS draft report, and I'm calling it draft because it's stamped draft. I knew it wasn't final when I received it. We got that because you ordered that the state give that to us last July. So I had this draft. I knew it wasn't final. Ms. Jennings knew it wasn't final. We've talked about it. We believed that we were going to get the final report by March 31st. We don't have that yet. It's the final report that we need. You also heard from Mr. Ray talking about the things that are mistakes in the CAS draft report. These reports go through a peer review process, and they can look a little different when they come back out on the other side. Usually not vastly different, but they can. They go through their process. It's that final product that I need that. I need to know everything they relied on to do their work. I need to know what this draft report is going to look like. The court should know that when we get to trial, likely Agent Valance is going to come in and talk about his CAS draft report. He's going to be an expert in the field and talk about what he found and why he found and what he relied on to do that. I'm going to come in with an expert that's going to explain what his work did. Now, if the work aligns and Nicholas Valance and our expert aligns, well, that's just going to be shorter. But right now, it's definitely not looking like that. It looks like they're going to have their side, and we're going to be talking about what the data shows.
We differ on a few factual issues.
So what I want is the final report that we were told would be available by March 31st. I need time to work on it.
Sure.
What I want is a full list of what was used to create that report, what was relied on. I have to be able to see if I can recreate that. I have to see what was right with it and what was wrong with it. So I don't have those two things, right?
Is it possible that it's just not completed?
It is possible.
A final report?
It is possible, but I need you to order that come to me. And I don't think Ms. Jennings doesn't want to give it to me. But if you order that I get it, then I'm going to get it a lot sooner, I think. I'm not saying that Ms. Jennings is sitting holding it behind her back. I'm saying I don't now know what's going on. The FBI told her it was going to be in by March 31st. We hit our deadline to disclose our alibi. And all of a sudden now they need to redo something in the report, which shocks me because of the things they said that they relied on were things that already existed.
Here's my concern with you telling me that at this stage of things. Where in the record is that currently?
So now I really need to know what they're relying on to do this report, and I really need to see the analysis, and I really need to see the final report.
Sure.
I have to react to it.
Since we're talking about this, Ms. Jennings, do you want to just respond to that? Whether or not this is still a work in progress, or what's going on?
Right, Your Honor. As I know right now, that report is not in its final form, and it has gone through a peer review process. My understanding is it's still in that. I have been told that yes, it's not a matter of redoing anything, but as they receive additional information, they just want to double check their work. They want to make sure that when they get the final report, it's accurate.
That's the part that gets me is these Kohbergers that are just brain dead. Like, he doesn't have an alibi. You know how many times Ann has begged him to give her an alibi? He won't give it because he doesn't have one, and he's never going to have one. The dude did it. It's that simple.
So we are still waiting for that final report to ensure that it's accurate. And as soon as we receive it,
I'm sorry. Do you have a time frame for that? I told you when they expect to be finished.
I don't have a final time frame. They originally told us it was projected to be completed by June. next month. So I'm hoping to get it within the next month. Multiple completely false narratives are the exact reason why. And I'll try to make this quick. I'll kind of go through each of these items that are still out there for discussion. But just to give you a little bit of perspective of what all has been provided to date. Simple. To date, we've given 15,691 bait-stamped pages of discovery. So for a little context, this is too much binder. It would be about 39 of these. We've given 13,758 bait-stamped photographs. That's about 34 of those binders of photographs. We've given 911 AV dumps. Those are digital files. In addition to a massive hard drive, about 50 terabytes full of discovery. And that includes audio video from about 285 interviews, 15,000 video clips from approximately 79 businesses, 8,000 video clips from approximately 10 residences, 417 files containing call detail records, multiple terabytes of records for 11 computer devices, 17 cell phones, multiple social media accounts, and 4 tower dumps.
Ms. James,
4 tower dumps. In addition to records regarding well over 17,000 tips. We've given multiple terabytes of records in response to the 71 grand jury subpoenas, as well as the 101 search warrants that were done in this case. We have facilitated the defense viewing the physical evidence on multiple occasions, as well as facilitated additional DNA trace evidence to be examined at their request. We've had a consistent pattern of loading up discovery and providing a hard drive to the defense on an almost weekly basis. And just to be clear, we're going to continue to do that. As we receive discovery, we review it, we load it on our hard drive, and we give it over. Now, going specifically through each of the requests, we've already dealt with in the 4th motion to compel. Item 214, we've already argued. Item 219, we've already complied with. The CASPERS logs. We heard the testimony, and what we know and what the judge heard testimony for is that CASPERS is just a software program that allows investigators to put in like the records received from a cell phone provider like AT&T into a software program and they kind of visualize. Detective Mallory testified he got the raw data set from AT&T, used the default settings for the times in question. It produced a map. He took a screenshot of that map. We provided that screenshot. He only did this in response to our request to provide a visual for the grand jury. We've been told that optional session files were not created or saved, and that this item simply doesn't exist. In the current version of CASFIZ, the user settings aren't automatically saved in an exported session, but instead it just returns to default settings. I asked Detective Mallory about this. He advised us that he used the default settings. It doesn't take much time or effort to redo this, which is why he didn't save those logs. That's his normal practice. He just saved the screenshots and we've provided that. We agree, we will double check. We're doing that throughout all of this. To our knowledge, there are not tower documents that were relied upon, but we will double check and inquire, and if that exists, then we will turn it over.
If I had to pick a time when the wheels fell off the wagon, that's the date.
So this is really problematic to be told these varying things and then have something else produced on the day of testimony. We are going to request that for order, that we have the tower list used by Detective Mallory and access to the CASFIZ program so our expert, Mr. Cy Ray, can go through and see what Detective Mallory did. That it's imperative that we be allowed to do that. That's the only way to recreate what Detective Mallory did.
226 has to do, well, first the request was for the AT&T Hemisphere program, and then it detailed several other things below it. And we were told they didn't use the Hemisphere program. And you're right, language is important as to exactly what's being requested. And now after a series of back and forth, they're saying that they want AT&T timing report. We have been told if that's referring to timing advance records, those records don't exist. We do have these location records, the DVOR records, and we've given those over. Now, the second part, it says that investigators recently obtained certified records from AT&T, and that'll be disclosed in upcoming discovery production. My understanding is that that's not related to the above. It's not related to Brian Kohberger's records. It's related to other records that were done later for other folks. But we will be providing that in the next production doc.
Thank you. Any response?
Your Honor, just really briefly, I want to talk about item 226, the Hemisphere program. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for this time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that...
The other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once, and they said, oh, no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
The 7 days that he's back home?
maybe.
I'll ask the state about those, if they receive those. I'm not sure their search warrant covered that time frame, but...
Your Honor, I would say that it did, and I would say their first search warrant was just a 48-hour period. It asked for timing advance records, but then the second warrant...
You would agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified? You would agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified?
Your Honor,
An officer of the court.
as an officer of the court, I would like to ask Nick Balance that, and here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've worked
You're giving
with.
me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay. But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
because they were asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay. So where's the evidence that Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't because they didn't know who he was.
You're correct. They didn't know who he was until, I think, about December 19th.
Right.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of them.
What you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. we've heard different things now than I've heard at different times in the past about this, particularly about the 7 days. That's newer information to me now. But the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my attention more recently.
Related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that, and you...
I understand your confusion and concern previously. What I don't understand it is now.
Now, the second part, it says that investigators recently obtained certified records from AT&T, and that'll be disclosed in upcoming discovery production. My understanding is that that's not related to the above. It's not related to Brian Kohberger's records. It's related to other records that were done later for other folks. But we will be providing that in the next production doc.
In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
He is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this. And you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he had supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time. For all I know, he didn't name names, he didn't identify it, he didn't put it into any context. The state had indicated and that provided AT&T sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that that was available to them by the time Mr. Kohberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him a question is really what I wanted to be able to do. And that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury.
Thank you.
At the time of trial.
That will satisfy me. Thank you.
I just for Mr. Ray's information, because he wasn't here the first day I started this trial with you folks. I said, I don't want theatrics. I don't want accusations that aren't supported with evidence about supposed bad conduct of the parties. You're all professionals. I respect you all. And the accusations he made in there are very concerning. The kinds of accusations, if true, that would get people disbarred. And so without any evidence and apparently sidestepping the clear explanation, he makes those. And so that doesn't make me happy.
And to address the court's concerns of what's been raised, I think the only issue out there, I have the 2 search warrants. The state asked for the AT&T timing advance records in our search warrants. The state wanted that information from Mr. Kohberger. We did not receive it. I did not receive those records from AT&T. I do not have them. Thank you, Your Honor.
All right. There's not been a showing that those records were available, and I think it would be unfairly prejudicial to try to impeach the testimony of the agent that somehow he hid or didn't provide or didn't use records that he didn't have available to him. So absent some factual showing that he had them available, I'm not going to allow questions about that, and I'm not going to allow testimony about that. Now, if you want to voir dire him before he testifies in front of the jury, I'll allow that. And if you show a factual basis for it, I'll allow it. But you haven't at this point.
I appreciate the opportunity to ask the question outside the presence of the jury. Thank you.
Thank you.
Thank you. Any response?
Your Honor, just really briefly, I want to talk about item 226, the Hemisphere program. Ms. Jennings asked me if we meant the timing advance program, but it's one and the same. I just heard her say that those records don't exist. I just need to be clear, if they don't exist, then I need to know that. If they do exist and they were used, I need to have them. She mentioned that item 250, that's the balance training records that we have. That we don't have that. That's balance training records related to the use of the Gladiator machine. We don't have those. 251 is partially complied with. That's the certificate on whether the Gladiator machine was working appropriately. We need the follow-up the next time that machine was put back for testing. Both machines, there were two. 263 and 264, Balance and Kennedy's past training records. I'm happy to hear that I'm going to get those. With regard to the videos on exhibit RR that the court has under number 21, this is where the business said they already had given over their videos, and Ampersand and One World Cafe are both listed on that as well. So they were given to somebody to go to Moscow Police Department at some point in time. And that's it for clarifications for me. Thank you.
Great. Excellent.
Really important with the misleading of the magistrate. When you look at 1A, that's the map we looked at earlier today, where there's the whole loop around, but there's a blue line as if pointing the car towards Moscow, and that's not what happened. They then report the phone stops reporting to the network at 2:47 a.m. And that's not right. We submitted their cell experts report that say the phone stops reporting at 2:54 a.m. We submitted 2 affidavits to you from our experts who have worked with the call detail records, and that's just not right. Don't get caught up in thinking 7 minutes don't matter here. We're talking about ground that can be covered in a vehicle in a short time. We're talking about 2 towns that are fairly close together. And so the way a car points when they go off a network matters a whole lot in this circumstance. That's not corrected in any of the affidavits. That's the part that's really exculpatory to Mr. Kohberger, is what direction, when the phone stops reporting to the network, what direction is the car traveling? And you can know that based on the cell towers, the handoffs from tower to tower as it tracks where a phone's going. The FBI knows how to do this. They chose not to do this. They chose to take a time 7 minutes before it really stopped reporting. And they chose to make a map that showed a direction that that phone wasn't traveling in to create a false narrative for the magistrate to rely on to find probable cause.
Does that make sense?
Yes, ma'am. Sounds good.
All right. And Judge, I have paper exhibits for you and for the witness. And so I'll go as fast as I can, but I want you to be able to look at what he's looking at. So we're going to begin with the first AT&T warrant. Prior to this case, had you ever secured an AT&T warrant?
No, ma'am. I don't believe I had.
And so, given that, who did you rely on in creating the warrant for
Largely
AT&T?
Special Agent Balance. Obviously, he's the CAS expert, so I relied heavily on his input.
Is the paragraph that talks about Mr. Kohberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, I believe it is D1B and C. That's an email from Nicholas Balance.
At the time that AT&T Warrant 1 was secured, were you co-located with Special Agent Balance?
I believe so, yes.
Can you, in terms of being more specific, it was December 23rd. Were you two co-located at that time?
I believe so, yes.
And he's talking to the detective in Moscow about the dates that he says this thing happens.
And I know co-located has been talked about in court a couple of times, but can you just explain what it means for you two to be co-located since he's from DC?
Certainly. Yeah, he was in the same building as I was, just mere feet away from the command post.
And he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location.
Okay, so when you say mere feet away, were you guys in like a cubicle setting or were you in offices with doors? What was this setting in terms of proximity to each other a few feet away?
Yeah, separate offices with doors, but in the same second floor of the Moscow Police Department.
Moscow has, I think, 2 cell towers that service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not.
Are you aware of Special Agent Balance in his work in doing AT&T records, having any access to AT&T records without a warrant?
I'm not aware of that, no.
Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records. But based on those records, they absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist.
Are you aware of him having any ability to review AT&T records through any portal without a warrant?
Not to my knowledge, no.
They put it in there so that the judge would think that this was the right person.
But let's go from the uncurious to the downright nosy. How many illegal FISA queries have occurred under your leadership of the FBI?
And they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IgG identification off to the side, but then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking because that's what you're trying to say, and you know that's not true. This court can rely on our proffer in D1B and in the cast draft report and in the cast final report because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate.
So I guess the question, Director Wray, is did you not know when you were answering these questions that the FBI was engaging in these illegal searches, or did you perjure yourself to Senator Lee?
I certainly didn't perjure myself. At the time that I testified in front of the Senate Judiciary Committee, I didn't have that piece of information. I will add...
Well, that was a court order. You didn't have that piece of information because the court hadn't yet rendered a judgment. Did you not know when you gave the untruthful answer before Senator Lee that this was going on?
It was a truthful answer. I did not believe FISA had been involved in the January 6th
But it was. So you didn't... The answer is the FBI has broken so bad that people can go and engage in queries that when you come before the Congress to answer questions, you're like blissfully ignorant. You're blissfully ignorant as to the unlawful queries.
The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that. We'll move forward to the set of warrants that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants. The fact that Mr. Kohberger gets arrested, his apartment gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car, there's no he wasn't connected to that house, to the people in the house. Your Honor, I'm
Maybe I thinking of a different date for the AT&T at the cell tower stuff. So you're still talking about the cell tower stuff?
No, I mean, that stuff applies to every single warrant we have because that was
I thought
early.
you transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about.
Some other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in and of itself probable cause to support any of it from there?
Your Honor, the DNA I'm talking about is the lack of DNA in Mr. Kohberger's car and the lack of DNA in his apartment, the lack of connection to the individuals.
What is that? Even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA in the sheath and Mr. Kohberger. Isn't that probable cause every day and twice on Sunday?
Not in this context. Not in this context because of the IGG work, because I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's going to be the ultimate question. You're
killed by a knife, it probably means a lot.
It might mean a lot.
Probable cause is not a proof beyond a reasonable doubt standard. It's probable cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that.
Well, I think it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known, I think that there's a lot of pause even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about, let's just go with the car. Let's just go with.
I understand the lack of evidence of DNA material or other victim-related material in the car and in his apartment, as asserted, but I'm not sure how that precludes probable cause when there's a direct DNA match. There's plenty of reasons that might be the case. And when a magistrate's looking at this, they have a direct DNA match to a person from a object likely associated with a murder weapon. I've not yet a magistrate would not find that probable cause.
If the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say, there's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, they told the magistrate about, that this is the video, this is what matters, it parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked, there's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Kohberger, and it matters a whole lot.
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light of a positive DNA connection would cause any magistrate to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence when there are other things in the affidavit or affidavits at that point that could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out that was in one of the affidavits. I guess, and I don't intend to argue with you about it. I understand your other arguments, but when you get to once they have the actual DNA, evidentiary DNA, it seems to me that it's an uphill battle to say there's not probable cause at that point.
Well, Your Honor should never get to that question, but I'm going to answer it for you. But you should never get to that question because you should have already found that AT&T 1 and AT&T 2 were terrible, and there's no probable cause for those, and they just build on each other. So you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe it.
Well, I'm just not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
Okay. I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway because you brought up blood DNA of an unknown individual that was found, I think, on the handrail.
Yes.
Doesn't that necessarily not exclude Mr. Kohberger? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
If what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them, matter. What's the other explanation? What's going on with this investigation? What's happening here?
Given the timing of these records, from what I can tell in the emails that were produced by Detective Mowry, these records were generated on the 23rd of December. It's when everything started with probable cause statements. If I had to pick a time when the wheels fell off the wagon, that's the date.
That's exactly the point, Your Honor.
There are statements and there's assumptions made in the records that will never be supported by the data.
What other explanation is there? The magistrate wasn't given a chance to ask that.
There's a lot of claims that are said in these emails, and even the name files of the records are problematic. It does not represent what it's claimed to represent.
She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence.
Sounds like those might be pretty important to us, defending Mr. Kohberger.
I could give examples, but I know it's a very technical thing, so it could be extremely impactful to either side. I'm not saying just in defending Mr. Kohberger, it could be extremely impactful in prosecuting Mr. Kohberger.
She wasn't given a chance to ask any of those questions.
The problem's the problem, not what the data helps or hurts.
Several of the warrants, and then Mr. Logson's going to cover 4. So I'll just wrap all of my argument up instead of getting up and down for each one. My oral argument is not meant to rehash every point briefed or every argument briefed. I'm giving you big picture comments based on the testimony, but I want to make it clear that we're not waiving any written arguments. While I question Corporal Payne and Detective Mowry about some exhibits, but not all, it was not an indication that others are not important. I wanted to make important points, but not belabor. With IGG and Franks having been addressed yesterday and the fact that the primary issues that I'm addressing have to do with general warrants, I'm not going to rehash those arguments, and I'm going to focus on the legal issues, beginning with the AT&T Warrant 1, Pen, Trap, and Trace, also known as AT&T 2, and the cell phone/USB drive. The Fourth Amendment requires particularity sufficient to prevent the exercise of discretion by an executing officer. The particularity requirement's objective is that necessary searches should be as limited as possible. A search warrant must be particular enough so that, as to what is taken, nothing is left to the discretion of the officer executing the warrant. The government cannot seize the haystack to look for a needle. And there is an undisputed privacy interest in cell phone data, including cellular site data pursuant to Carpenter. All 3 of these warrants were issued in December 23rd and early January 2023. The 2 AT&T warrants were issued on December 23rd, 2022, within an hour of each other. The first did have a temporal narrowing. AT&T 1 had November 12th, 12 a.m. to November 14th, 12 a.m. The warrant itself was extremely broad and did not incorporate the affidavit. In support of this actual failure to incorporate, the officers admitted that they did not incorporate in the search, but to the extent that the state is going to argue that when the warrant says upon offer and proof, that that is the same as hereby incorporates an affidavit, I pointed out the language in certain search warrant affidavits to show you that they do know what it means to actually use the language herein is incorporated Exhibit A, and that same language is not used in a single search warrant affidavit. So the incorporation that would be a remedy for this issue potentially of particularity doesn't exist when the search warrant affidavit is not included. Even if, for some reason, you were to determine that there was English language meaning upon proof and oath is the same as hereby incorporated, the language in the search warrant affidavits themselves is extremely broad. The affidavit of return signed by Detective Paynes, this is on AT&T 1, says that the warrant was served by email, and as he indicated, it did not include the search warrant in support. The description of the property in Exhibit A to AT&T described the property as just a phone number with no other description of the property, which indicates a lack of knowledge of what was actually seized and going to be searched. The second AT&T warrant and install pin trace was requested within 1 hour of the first warrant return at 3:50. The data from warrant 1 was analyzed such that by Special Agent Balance, such that Detective Payne was relying on Balance in his affidavit to support it by saying that the data that had been in their hands for less than an hour supported that the phone was possibly off going south on Pullman at 2:42 a.m. And there is just got to be a question for everybody of how does this massive amount of data get analyzed in an hour to create a second, broader warrant? The warrant language in AT&T 2 pin trap trace is extremely broad, and the time frame goes from June 23rd, 2022 to present. The crime of homicide was stated, but the date of the crime was not stated. There was no other specificity in the actual warrant. The warrant asked for extensive data, location data, timing reports, cell tower information, and installation of a pin, trap, and trace, among other many things. And when the warrant was served, a check-the-box form was included as a cover sheet to AT&T. Turning to the cell phone is first seized when Brian is arrested. It's copied by Special Agent Tanzola without a warrant, and then that USB drive makes its way to Idaho in an unclear fashion. It sounds to me like it came back with Corporal Payne, who was there for the arrest. And when that warrant is obtained for that USB drive, it's put in a safe with just a copy of the warrant that has no date of the crime, and there's nothing particularized about what is to be searched. This creates a general warrant with 100% total discretion and nothing to limit the search. And if you believe that access within a database by somebody unidentified other than Mowry, who's going to evaluate that warrant, that they're going to look and pull that finalized search warrant from the database that everybody supposedly has access to, looking at that search warrant affidavit, there's full discretion to search the USB drive. There's no limitations and no efforts taken to address that.
I do love building bridges.
Right of privacy in the information that we have in our Amazon goings about why should the state have to have a warrant for that. I thought we set it out pretty well in the briefing, but I think
The thing about bridges is that every one of them is an invitation to people on the other side to come over and play. Some of those people might hate you. Some might just be simple or scared or naive. Some are enemies or trolls or federal agents who are best left under the bridge. Those are the ones who will try to steer and poison whatever you're doing if you let them come across. Every bridge could make you stronger, or it could destroy everything you want to defend and protect.
But I think the big concept and takeaway here is in Carpenter and Riley, the United States Supreme Court starts doing something different. And I think what the court is starting to recognize is that to a great extent, the United States has become a sort of panopticon. That is, the concept of the panopticon is you have a prison in which you only need a small number of guards because you have a very heavy-duty surveillance system. In the United States, we have via our phones, via the internet, much of what we do is now surveilled and very easily accessible. And so the fact that we have the third-party doctrine made sense when it was being adopted back in the 70s and the 60s. It stops making sense once all of this information is easily accessible in the way that it is.
Happy November. Whatever you do this month, don't feed the trolls or the feds. Don't let them feed you. Don't take the bait. Don't play with fire, but burn whatever bridges you need to burn.
And so our point is that the judiciary has to have a role in this.
Oh, and thanks for being my neighbor. You can cross my bridge anytime you want. That's your effect.
There has to be a judge between us and the executive. Otherwise, we're essentially allowing the executive to know everything about us all the time. And so the state makes the point that, similar to the one that Professor Kerr made about going and getting bank materials, once those were things that could be done simply and efficiently via these records, a person didn't have to go out and get the cash. The state argues in this case, because of Amazon, Mr. Kohberger didn't have to go someplace to purchase items. All of that would have been out in public, but he's doing it on his computer, and so why should that make it private? And the reason why that has to become private, Your Honor, is because of the vast amount of information that is now so easily accessible to the government. If we don't require a warrant, we essentially put all of ourselves at hazard of being snooped on at any time. And so I also just want to briefly bring up, I think yesterday the court had talked about privacy rights with the IgG databases, and I certainly want to make sure that we are preserving that argument. We included it in the briefing. We do believe that Americans have a privacy interest in the genetics they share with other people, and that other people then place within these databases. So that is not something that we intended to abandon in any way yesterday. If the court has no other questions for me, I would rely on the briefing.
Thank you.
Thank you.